Hey folks, it's Dave Neal here. We have big updates in the Blake Lively versus Justin Baldoni court battle. Blake Lively has responded with a 15-page motion here. It is the reply in support of motion for attorney's fees, treble damages, and punitive damages under California Civil Code, Section 47.1. I'm going to read it for you guys in its entirety because it's not too long, and a lot of folks online are already irate. This is going to be a featured video, no other stories, so let's dive right into it. So here's what she is asking for. She's trying to avoid a jury trial, dismiss this thing, and punish Baldoni for even trying to retaliate against what he says are baseless claims. And again, this might leave you upset. Don't take it out on me. Hit the subscribe button if you enjoyed the extra content. Introduction. The Wayfair parties brought a meritless defamation action in New York under California law using California-based attorneys representing a California-based company. A company based in large part on a complaint Ms. Lively filed with the California Civil Rights Department. The court dismissed the Wayfair parties' lawsuit against Ms. Lively, including their defamation claim and every other claim they alleged. They now seek to repudiate their invocation of California law to avoid the consequences of their failed litigation strategy. They advance three arguments for why the court cannot or should not rule on Ms. Lively's motion, all of which fail. Now, what's interesting here is the defamation claims by Justin Baldoni failed because Blake Lively's protected by the fact that she made those claims that she made against Baldoni in the California civil rights, claim that she made. If she made those on a blog, he might have a shot, but she did it in a protected space. First, the Wayfair party suggests that this court cannot rule on Ms. Lively's motion because it presents issues of first impression under Section 47.1, including ill-defined constitutional concerns and conflicts. It goes without saying that this court has the authority to rule on matters of first impression, including Ms. Lively's motion, especially when, as here, the Wayfair party's own claims and litigation conduct before this court have put Section 47.1 at issue. Nor do the Wayfair party's free speech arguments under the Noor-Pennington Doctrine in California's litigation privilege change this, as the Second Circuit has not decided whether Noor-Pennington even extends to non-commercial litigation. The canons of statutory construction compel the conclusion that Section 47.1 carves out an exception to California's statutory litigation privilege. Second, the Wayfair party's argument that Section 47.1 does not apply extraterritorially where Ms. Lively is not a California resident and the film was shot outside California is similarly meritless. None of the Wayfair party's case law addresses application of a state's law when the party resisting application itself brought claims under that state's law. Even if they did not invite application of Section 47.1 upon themselves, which they did, there exists a sufficient nexus between California and the Wayfair party's retaliatory defamation action based on Ms. Lively's California complaint, the only conduct relevant here to justify its application. So Baldoni's side is saying, we shot the thing in New York, you live in New York, and you filed this thing in California. And she's saying, well, who cares? And again, California does have this 47.1 section, which is like the MeToo law, which hasn't really been challenged. It's there to protect people, but at the same time, it could absolutely be abused where you're not allowed to retaliate or respond. A response by Baldoni would count as a retaliation, even though he's saying, I'm innocent. I'm just responding to these crazy claims she made about me. Third, the Wayfair parties argue that the court cannot apply Section 47.1 without factual findings that Ms. Lively acted without malice and had a reasonable basis to make her complaints about harassment and retaliation. In effect, the Wayfair parties argue that the court cannot conclude that Ms. Lively is the prevailing defendant in the defamation action, which has now been dismissed with prejudice or abandoned in its entirety. Instead, they argue Ms. Lively must endure a jury trial to prove that she already prevailed. This makes no sense and runs counter to the California legislators' express intent to provide remedies to a successful defendant at the earliest stage, typically through a motion to dismiss. In a perverse twist, the Wayfair parties attempt to justify the exact type of protracted litigation the statute was designed to curb by arguing that Ms. Lively's affirmative claims, which with which the Wayfair party's separate lawsuit had previously been consolidated present the same factual issues as her motion under Section 47.1, and thus must be decided together to avoid inconsistent rulings. This is wrong. Ms. Lively's claims do not necessitate Ms. Lively to prove that she acted without malice. The Wayfair parties did not allege otherwise in their lawsuit and should not benefit from the fact that Ms. Lively's affirmative claims remain standing. Finally, the Wayfair parties argue that Ms. Lively has not established a basis upon which the court can calculate treble damages and cannot establish her right to punitive damages absent a factual finding from a jury. Not so. Ms. Lively has already requested a schedule to introduce evidence of her actual damages, which will be established by the close of expert discovery on November 14th, 2025, in which the court can then treble. Moreover, California precedent confirms that a judge may award punitive damage under California Civil Code, Section 3492. Indeed, that authority should apply with greater force, whereas here, the malicious, oppressive, or fraudulent conduct is the Wayfair party's litigation conduct, which is evident on the court's own docket. The Wayfair parties should not be permitted to avoid the consequences of their retaliatory litigation tactics any longer. The court can and should rule on Ms. Lively's motion at this juncture and set an evidentiary hearing to establish Ms. Lively's attorney's fees and damages. Section 47.1 does not infringe the Wayfair party's constitutional rights. The Wayfair party's suggestion that it is somehow improper for this court to rule on Ms. Lively's motion, since California courts have yet to interpret 47.1, is incorrect. So Baldoni's saying, we don't even have an interpretation of this law, whether it's, the scope of it, and they're saying, well, who the hell cares? Let's party. The court is plainly empowered to interpret Section 47.1 where the Wayfair party's own litigation conduct implicated it, and the court expressly allowed Ms. Lively to renew her arguments thereunder. If the Wayfair parties did not want to face the consequences of California law, they should not have invoked it in the first place, and on multiple occasions thereafter. The Wayfair parties also assert that this court cannot rule on Ms. Lively's motion because it presents issues of first impression, including constitutional concerns and conflicts. They argue 47.1 infringes upon their First Amendment right to bring unsuccessful claims under the Noor-Pennington Doctrine and California's litigation privilege. Both arguments fail. So as far as I'm concerned, Blake Lively could make claims about me. She could make claims about me, and I wouldn't be able to defend myself. I wouldn't be able to, respond in court, right? That would be a retaliation. This rule, and again, nobody wants to protect victims more than me. This rule is ripe to be taken advantage of, it seems, if they don't, set some precedence on how they can narrow the scope. I don't know. Just a thought. What do I know? The Wayfair party's Noor-Pennington challenge bears bones as it fails to raise free speech concerns. A court in the district rejected a similar challenge, noting the Supreme Court's caution that the PRE standard is a doctrine of antitrust law, and that its holding is firmly grounded in the text of the Sherman Act in the context of antitrust liability. So they get into all the nitty-gritty about, Blake's response to the arguments that Baldoni was making here. And again, how the judge responds, I have no clue. Moreover, any risk that Section 47.1's treble damages provision would chill petitioning activity in the form of defamation suits is outweighed by the risk recognized by the California legislature that retaliatory defamation suits would chill reports about sexual harassment. Finally, even if Noor-Pennington applied to Section 47.1, the Wayfair party's case would fall under an extension of the sham exception as a baseless abuse of judicial process based on the patent deficiencies in their now dismissed claims. The Wayfair party's arguments under California litigation is equally deficient, as the California Supreme Court has emphasized the litigation privilege is not without limit, and then they go into those cases right there. These exceptions have all been guided by the settled rule of statutory construction that particular provisions will prevail over general provisions. Based on this principle, clearly reflects the California legislature's intent to carve out an exemption to the litigation privilege to deter retaliatory defamation actions based on reports of sexual harassment and retaliation. Indeed, like each of the exceptions discussed in Action Apartment Section 47.1, is more specific than the litigation privilege and would be significantly or wholly inoperable if its enforcement were barred when in conflict with the privilege. I think the merit of this Section 47.1 meant for workplace harassment was, meant so that victims could come forward, file their complaint, and then they wouldn't be retaliated against. Boom, done. But the fact that this involves celebrities, Blake, Justin, means that any complaint once shared publicly really is a defamation to the other person if the complaint's not true. And that's why you have to be impeccable with making sure you're telling the truth and letting someone have the chance to defend themselves. So I think the fact that this does affect their livelihood is concerning to me about how they're going to rule here. So they go into the nitty gritty. I'm not going to cover the nitty gritty. Finally, let's go to finally here. The Wayfair party's assertion that a jury must determine malice under Section 47.1 fails, where the facts are undisputed as they are here given Miss Lively is undeniably the prevailing defendant in the failed defamation action. The applicability of a privilege is a question of law, blah, blah, blah. The Wayfair party's extraterritoriality argument is meritless. The Wayfair parties argue that the court should not apply Section 47.1 against them because Miss Lively is a resident of New York and the underlying conduct occurred in New York. The argument fails on multiple fronts. And by the way, this is crazy. You live in New York. Imagine you live in New York. You did a gig in New York with a production company in New York. And you go to California and you file this complaint because it's a pretty good rule they got there for you. Wild stuff. None of the cases cited by the Wayfair parties address application of a state's law that the party opposing application itself invoked. So, again, I'm no lawyer, so I can't tell you what I think about all of this, but we did consult ChatGPT. I shared this on the Morning Rush. She contends the Wayfair parties cannot reject this law after using it. And from the comments that I've seen online from folks that are checking this out, they say Blake Lively's batshit crazy. She's insane. She's unhinged in the expectations she's making here. I don't know if that's true. I really don't. The Ninth Circuit has squarely rejected. Is this smart for her? I have no idea. Well, I guess it'll depend on what the judge responds with. Even if the presumption against extraterritoriality did apply here, the court should still apply Section 47.1 because the conduct relevant to Miss Lively's motion has a sufficient nexus to California. The Wayfair parties principally argue that there is no such connection because the film was shot outside California, and Miss Lively is not a California resident. This misses the mark. The relevant conduct here is the Wayfair parties' retaliatory litigation based on statements contained within Miss Lively's complaint to a California agency, not the sexual harassment and smear campaign allegations underlying Miss Lively's affirmative claims. To the extent the Wayfair parties concede that the filing and dismissal of their claims is relevant, those claims are clearly tied to California. All right, it is undisputed that Wayfair Studios is a California-based company. You got me there, which retains California-based attorneys to file a defamation action under California law. All right, so that's how they pin it on California. Finally, the Hollywood sign is in California. It's a Hollywood production. What are you going to do? Finally, strong public policy considerations weigh in favor of applying Section 47.1. All right, so they say here, to ensure that perpetrators cannot misuse litigation as a tool of intimidation and retaliation. Can you believe that? And I know they're just citing this here in bold, but they're just like accusing Baldoni of being a perpetrator with no evidence whatsoever. It's wild stuff. Factual findings as to Miss Lively's affirmative claims have no bearing on whether Section 47.1 applies. You can't handle the truth. We're not going to share with you the truth. The Wayfair parties further assert that the court cannot rule on Miss Lively's motion until a trier of fact determines that Miss Lively acted without malice in communication about the Wayfair parties' sexual harassment and retaliation, and that Miss Lively had a reasonable basis to report her concerns about the workplace. Miss Lively is unquestionably the prevailing defendant. The court's dismissal order, which holds that Reynolds, Sloan, and the New York Times did not act with malice, including because Miss Lively gave them no reason to doubt her version of events, only bolsters this conclusion. And by the way, will Baldoni file an appeal on that dismissal of the defamation claim? I have no idea. To think that Ryan Reynolds did not act with malice is insane. He created a character about Baldoni. I didn't want to believe it at first. Nice spool. I was like, oh, come on. Internet people can put things together that don't exist. Confirmation bias. Ryan Reynolds absolutely smeared the hell out of Baldoni, and I think Baldoni would have an easy time proving it if the thing wasn't just flat out dismissed. To insist Miss Lively pre-prove these facts at trial would cut Section 47.1 off at the knees. The California legislature made clear that Section 47.1 remedies must be made available at the earliest stage to prevent protracted litigation that would re-victimize complainants. You don't want to re-victimize Blake Lively. You know what? Let's just dismiss this whole thing. Baldoni, you pay Blake $10 million. We don't want to re-victimize. What are they talking about? All for the claim she made that they burst into her, room and he was nibbling on her lip during a slow day. I mean, things that have been debunked. They were sharing porn on set, just wild. He was hiring his buddy to play the gynecologist. I mean, these things were quarter truths that with any evidence, people go, oh, come on, what are you talking about? So either way, nor do the Wayfarer party's attempts to muddy the waters by claiming that Miss Lively's Section 47.1 motion presents the same factual issues as her affirmative claims withstand scrutiny. Whether Miss Lively acted without malice to make her complaints is not a necessary element of her affirmative claims. Miss Lively does not have to prove that she made a complaint at all to prevail in her sexual harassment claims. As for retaliation, Miss Lively only must prove that she engaged in a protected activity, that she opposed unlawful harassment. The Wayfarer party's contention that Miss Lively must first prove her entire retaliation claim imposes an unwarranted burden on Miss Lively, especially where the Wayfarer parties have already admitted they believed Miss Lively made her complaints in good faith. All right. And that's referencing a text message exchange between Mr. Baldoni and Miss Nathan, in which both agree that Miss Lively genuinely believes she's right and that all of this is unjust. And this court has already recognized the strength of the evidence in favor of a smear campaign. Miss Lively is entitled to actual treble and punitive damages. Finally, enfin, les Wayfarer parties contention that the court cannot award treble damages because Miss Lively has not yet established her actual damages fails. Indeed, Miss Lively seeks a schedule for the submission of damages evidence, which the court may then treble under Section 47.1. Further, contrary to the Wayfarer party's position, California courts hold that the judge or jury, as the case may be, has the authority to decide whether and what amount of punitive damages should be awarded. The court is therefore fully empowered to determine the application of punitive damages at this juncture. If the court concludes that further evidence is warranted, Ms. Lively seeks a brief evidentiary hearing on these discrete issues, which should be held separate from the trial on Ms. Lively's affirmative claims to avoid confusing the issues or the jury and to provide Ms. Lively with the prompt relief the California legislature intends. Conclusion. For the foregoing reasons, the court should grant Miss Lively's motion in its entirety. Boy, that was a big read. Kind of a bummer, right? What do you guys think? I'd love to know your thoughts on this. Does Blake have a chance? Again, is it the abuse of a well-meaning Section 47.1? Baldoni's hands are essentially tied. What can he do? Can't respond. Just has to pay her legal bills. It's like a bad divorce case without any of the banging, right? Unless you watch the movie. Boy, were they hot and steamy together. Say what you want about that movie. When he pulled her in there on the rooftop, I was like, get me a cigarette, right? I don't even smoke. Boy, 2 puffs. I didn't inhale. Okay, folks, that's it. We'll be back this afternoon. We're here at least twice a day. I think I got 5 videos today. It's a busy one. Make sure you're subscribed for all updates. We could have breaking news. This thing could be ending very soon. It might not go to trial. We'll have to see how it all plays out. We'll see you then. I'm Dave. This is The Rush.